So this is where we figure it all out, applications in the industry. So I'll start. We have 4 panelists in this last session to do all this. So I'll just start introducing everyone straight away. I mean, Jeremy, you've already been introduced. So we know he's the president and CEO of Venture Lab. And he's also a dear friend of the university because he's an IP-intensive supervisor. So with that introduction, I look forward to perhaps the others being IP-intensive supervisors as well. Rizzi Active, he's the Senior Director of IP at Sanofi Pasteur, and he's also a friend of the school because he's been speaking at the IP-intensive program, so maybe we could turn you into a supervisor. On his right is David Laliberté, and he's Director of IP Policy at Microsoft, and I plugged Microsoft at the very beginning in my examples, so thank you for being here. And on his right, there's Bill Chan, and he's IP Law Counsel at IBM Canada. So thank you very much. You come highly recommended from Leonora in IBM New York. So thank you for being here. Yes. So what I've asked the panelists to do is to stick their comments to the 10 minutes, and then we'll have a chance for discussion. So if we could start with you, Jeremy.
Okay. Just about 1:45, and I'm off to the races. Thank you, Pina, for, first of all, for asking me to come back. I look forward to this each year in my calendar. It's always fun to be with IP Osgoode and with Pina's team. My name's Jeremy Lauren, and I'm the CEO of Venture Lab, and you heard a lot about what regional innovation centers are at the lunchtime keynote from Bill Mantell. I thought I'd start first with just a brief summary background of who I am, how I get into this seat I currently occupy, and then I kind of feverishly took some notes. I'm not one of these fancy guys with one of those cool Microsoft tablets. I do it the old-fashioned way with pen and paper. So if I can manage to read my own notes, I'll be able to sound somewhat intelligent. So I authored a patent early on in my career, but I did it outside of academia. I did it, though, with a very good friend of mine who was a computer science guy at U of T. And we were successfully able to go on and author a patent that allowed us to raise funding capital and build what I call a micro multinational enterprise. So a company that you've maybe never heard of by name, but went on and employed lots of people and contributed to the economic base. And I did that in Kingston, in a place where there is a world-class institution. In fact, there's a couple of them. There's the Royal Military College, of course, Queen's University, and there's a community college in Kingston, St. Lawrence College. So lots of academic presence, but in the 90s, all those things you heard about from Bill Mantell didn't exist. There were no regional innovation centers. There wasn't even a technology association in Kingston. And so what ends up happening is if you are outside the 4 walls of academe, you kind of do it in a vacuum, and you fail a lot more than you ever succeed. And one of the things you may hear, or you do probably hear a lot about in the news, is how Canadians are extremely bright and very, very capable from an R&D capacity. We know how to innovate. I often like to say to people, we invented the smartphone, not Apple. People forget that it was actually done here, and it was done in the University of Waterloo by a dropout named Mike Lazaridis. It was created by RIM. It became globally popular in 2007 when Apple outsold us. So it's not the best technology that wins, it's the best sold technology that wins. So as I was sitting here this morning listening to some of the panels, I actually did a little test on my BlackBerry. I Googled the most popular student researcher in Canada. And then I Googled the exact same thing, only I said the most popular student researcher in the United States of America. I encourage all of you to do the same thing. What you'll see is a group of search results on government institutions that are out there in the business of helping students organize and commercialize their ideas. You won't see a single name, not a Jeremy Lauren in the mix. And then in the other search, you'll see university-led institutions full of students that are commercializing intellectual property and building global enterprises. And I'll leave you in suspense to pick which one is which. So that's an important statement, guys. It's a very important statement. And the problem in this country is that we have one open text. Everybody in the room know who open text is? Okay, so some, about half. So open text is Canada's largest software company. It was founded in 1991 by 2 University of Waterloo students and a couple of professors. It's $1.5 billion global enterprise today with 5,000 employees. That's the talent from within that Bill Mantell is talking about. Rather than encouraging Shell Corporation to come and set up shop in Markham or Vaughan, he's saying, we're going to create the next generation of open texts. And if anybody ever has an opportunity to go and hear Tom Jenkins, the chairman of OpenText, talk, there's a guy who, when he rips open his shirt, he has a flag of Canada tattooed on his chest. He's the proudest, most patriotic Canadian innovator that I've ever met in my life. He's absolutely inspiring. So if you have an opportunity to hear him talk, go and do it. Do yourself a favor and go and check it out. So imagine a story where in 1991, 3 or 4 people were in a university, and in 2012, just over 20 years later, we have $1.5 billion company that employs 5,000 people around the world. It's an absolutely remarkable story. The only problem is there's one. This country needs lots of open texts. It needs lots of RIMs. It was 10 short years ago, just about to the day that Nortel fell. And that same day, a lot of good, hardworking people like my mom and dad lost 25% of their retirement savings in one day. When a country has a single client dependency, just like when a company has a single client dependency, it's always going to create havoc and problems. Diversity creates a broad economic base and creates a sustainable country that can compete globally on any stage. So it's not that we're not really smart. There's lots and lots and lots of great examples of intellectual property right inside this institution and right across this country. The problem is there aren't enough people that want to do what the founders of OpenText did in 1991. And that's a challenge that I would leave everybody in this room to think about, and think about over the weekend, and think about it as it relates to your own career. I built a company outside of academe with no help from Queen's University or its Office of Research and Commercialization called Partech, because I wasn't a Queen's graduate. So there was no resource there available for me. So as a result, I raised my money in the Valley, and I was fortunate enough to exit to a multinational in Denmark. So the vast majority of the shareholder wealth went to the United States. The intellectual property and the jobs went to Denmark. I'm no longer in Kingston. I'm sitting in a university hall that I'm really thrilled to be in on a Friday afternoon, but it's not in Kingston. It's in York. It's in Toronto. So I think those are very, very important considerations for people who are thinking about student-led intellectual property and how we go about batting our chest and really promoting what we're capable of doing, and how we might think about commercializing intellectual property and turning it into great ideas. So just a couple of points and then I'll stop. I wanted to leave you with the thought that commercialization and entrepreneurship and student-led commercialization are forever linked. They will forever be linked, and they should always be thought about in that way, in this person's humble view. I would encourage you to think and look at, if you're interested in some of the things I'm talking about, organizations like the Next 36, which take students, put them together in teams, mash up ideas, and create startup companies. The Financial Post last fall wrote a fascinating article about the Next 36, and they said nobody should ever be fooled into thinking that every single one of the cohorts that comes through the Next 36 is going to become the next OpenText. But what you should remember is every single student who goes through the Next 36 will have an inbred culture of entrepreneurship inside of them as a result of the experience. And that will make them better in any corporation they go off to work in, whether that be the one they start in their garage or IBM or Microsoft. They will be better employees or entrepreneurs as a result of that experience. So check out the Next 36, because it's about doing those things that I'm talking about. I would check out the Guide to Intellectual Property for Graduate Students. It's published by the Canadian Association for Graduate Studies. Maybe all of you have read it already, given that you're law students, but if you haven't, it's a fascinating document. I don't have a background in law, but I could understand it. I thought it was extremely well written. I think it's a great resource if you're interested in this topic. And finally, Patents are important, but not the be-all, end-all. This was talked about a bit by Dr. Phipps in this morning's panel, and I really caught on to this theme, and I wrote, IP comes in many forms: knowledge transfer, customer relationships. All of these things are forms of intellectual property. It's not always about the ones and zeros that make up the algorithms of the software. Sometimes it's about the proprietary way in which we go about doing something. And the fact that we can do that better than anybody else is a form of intellectual property that allows us to go on and commercialize our ideas and turn them into enterprise class companies. I'll leave it at that, Pina.
Great, thank you. Rizzi.
Okay, so my name is Rizzi Active, and I thought maybe, hopefully, I can give you a little bit of perspective from a large life science company. It used to be called a pharma company, but it's life science now. We're actually just down the road. If you carry on Steeles and go a little further east, what used to be Connaught Laboratories. I sat through the morning sessions, and we heard a lot about entrepreneurship and innovation and patents, and I think I can talk, it's okay, and inventors. And I thought maybe I could give you a perspective of how a large multinational organization deals with these types of things, that maybe you can take a little bit of that away with you in the event that you ever get to the stage where you then come to a large company and try to sell your innovation to them or us, and you'll have some sense of what you might need to do to get to that stage. Maybe a little bit of background of myself, just to let you know that there's some validity of me sitting here. I came through sort of the normal channels, went to university, went to graduate school, not at this school, at a competing school a little further downtown, with the name of Toronto in it. And then I decided, I started a PhD and was a little bit disgruntled and thought, okay, fine, I'll go into the real world and work for a while and see how it is. And I ended up at a vaccine company then called Connaught Laboratories, and landed in the research and development group there, and was thoroughly thrilled in being able to work in a field that will hopefully one day lead to a product that helps save lives. I then worked as a researcher and actually had my own inventions and became an inventor and got granted patents. Through that transition, I actually got interested in IP and then became a patent attorney and actually ended up prosecuting my own patents, which was a really bizarre thing. Slightly biased, but a little bizarre. So that leads me to where I am today. So I've seen a little bit of one side of the street and also the other side of the street. Not as an entrepreneur, not as a student inventor. All my inventions came through under the roof of a larger corporation. But there's certain things you can take out of that and certainly use in an entrepreneurial setting. So with that as a background, we heard a lot about inventions. And so I thought I'd maybe talk a little bit about what is the invention? You, as an entrepreneur, you think you've come up with something, and it's the greatest thing since sliced bread, or the greatest thing since whatever the latest device is. And maybe I thought I would give you a little bit of a background of what we look at when we look at inventions. And of course, one of the things that you first have to look at is it has to fall into one of those categories that are deemed patentable inventions, be it in Canada or any other jurisdiction. We heard a little bit about the US, but you might think you've got such a great invention you'd like to actually patent it worldwide or in Europe or wherever. So you have to look at what falls into what's deemed patentable inventions under their acts, which are then interpreted by the courts. In some cases, that may not be that important to you. But also to remind you that to be patentable, you have to fulfill at least 3 criteria, right? You've got to fulfill the prior art criteria, and I don't know how much you know about patents per se, but I'll give you a very 30-second high-level view. You have to fulfill the criteria of it being novel and non-obvious. And you also have to fulfill criteria of, as I said, subject matter, and also utility. And also, we heard a little bit about disclosure earlier this morning on you have to disclose everything. You have to remember what is a patent, you know? It's a piece of property which you can then sell, license, use, but it's a piece of property that doesn't have a positive right. It has an exclusionary right. So just because you have a patent, you've got a little piece of paper or a plaque or whatever, it doesn't give you the right to do anything. It gives you the right to exclude others from doing what you have granted in your, what has been granted in your claims, but it doesn't give you a positive right. And so as part of that, when we look at people coming into us and say, oh, we've got this great invention, and they may even have some patents filed on it, we first of all do a due diligence and look, you know, at the technology. Yeah, that's something that fits with our the scope of what we do. But we also have to look at several things. One is, if we invest in that, do we have to get rights in other things in order to give us what's called the freedom to operate? Remember, patents don't give you any right to do anything. They give you a right to exclude others. So even though you may have a patent to the cap on this pen, there may be other patents that dominate that. So you would have to then get a license to those patents. So you have to keep that in the back of your mind. You may think, and it's not a disparaging remark, but you may think you've got the greatest invention in the world, but you have to do that analysis, that due diligence, to see whether you need other rights in order to then commercialize your IP. And that's something that you can either do on your own, or you can do that with the help of a partner or an investor or something like that. And that takes a lot of analysis, a lot of searching, and sometimes a lot of money, depending on the technology field. You know, everything's dependent on the field you're in. Certain fields are very crowded. For example, I'd say the IT field is pretty crowded, huh?
Yep, I'll say so.
That's it. Pharmaceutical field is also very crowded, the area where I exist. But there are other fields that are less crowded, so you could probably do some of those searches on your own. There's a lot of free information available on the internet. Don't believe everything you read on the internet, but you can certainly have access to a lot of information. All the patent offices in the world have access to their databases. So avail yourself of the free information before you then have to pay somebody to do that for you. The other thing we heard a little bit about was who's an inventor? And this is a very interesting area. We heard earlier that it's true, inventorship is a legal determination, not a emotional determination or a hierarchical determination. Just because you're in a lab and you have a professor that is your supervisor does not automatically mean that they are an inventor. Inventorship, we heard, has to be determined, and it has to be determined based on an inventive, what I like to say is an intellectual contribution to the invention. And what is the invention? The invention is what is claimed in the claim. So the way we normally approach it is that if somebody comes to us and says, okay, I've got this great idea, I've actually filed a patent application on it, one of the things that we look at in our due diligence is, are you truly the inventor of that, or are there other people who were not named inventors? And then the next question is, are you truly the owner? And I'll get that in a second. But when you come out of an environment such as a university, where you may have people who supervise you, you then have to look very carefully, not only at the invention as a whole, but also the claims to the extent that you're at that stage. Because not only do the claims change during prosecution, and you have to then readdress who the true inventors are, but if it's a group of people, not a single inventor, but co-inventors, those co-inventors may drop out depending on what claims eventually get issued. So as a right, what we normally do is when we look at inventors internally, we start off with the claims, and then you say, okay, that person contributed intellectually, that person contributed intellectually, that person did not. But then we also have to look at it when you get to the granting stage, because as I said, the claim scope may change, and one person who was an inventor when the claim scope was this big may not be an inventor when the claim scope is this big. So it's something that you have to address constantly at the beginning and at the very end, because the consequence of that is that you could have an invalid patent. Or you could get somebody who was not named a true inventor come back and challenge it. And companies generally do not like to take on patent portfolios where there are issues like that. The other thing that we heard a little bit about is that it has to be an intellectual contribution. So if you are the hands of somebody's idea, just because you did the work does not mean you're an inventor, right? You have to have contributed to at least one claim in the patent in an intellectual way. Okay, it's a very important thing. Also, authorship on papers does not equate to inventorship in patents. They're two completely different things. In the example I gave, if you've done the work, if your supervisor said, you know, I need you to do A, B, and C, and you do A, B, and C, and it works out really well, you may be either a first author or second author, but you may not be an inventor. Now, if you then do A, B, and you improve on C, you may be an inventor of the improvement on C, but you may not be the inventor on the whole A, B plus C. So you have to really analyze what it is your contribution is to the invention as a whole. You may have contributed to an embodiment of the invention, but not necessarily the totality of the invention. Those are things that need to be looked at. And so when we do due diligence, we obviously look at also ownership. Ownership's a big issue. We do a lot of analysis of small businesses that have come out of universities. So people were students in universities, they've now graduated, they've started their own business. And you have to look very carefully at those agreements that existed or did not exist, the case may be, when you were a student or when you just came out. So we heard a little bit about funding and granting and all that. You have to look at, first of all, the agreements to the extent that they exist as a student versus a university. And what I heard this morning is that York is a very open policy that you own your own invention. Not all institutions are like that. You know, I happen to be sitting here at York, so I don't have to expound too much on that. But there are many universities who require that the invention gets assigned back to the university. If the university cannot then find suitable tech transfer that out, then it may go back to the student or the inventor. But you have to understand your rights, and those rights can be implied or they can be explicit in a contract. For example, in a large company or in most companies, when you sign your employment agreement, if you look at the really fine print that you can't read if you get over 35 or something, it says that any invention, if you are hired in an inventive capacity, for example, as a research scientist, you're obviously hired as an inventive capacity. Anything you invent using company resources in the area that you are hired for is owned by the company, so you have an obligation to assign those rights. You're still an inventor, but you don't own it. Those rights then belong to the company who have provided you with a space to do your research, the funds to do it. In some cases, you can then, if the company does not want to go forward with that, you can then negotiate those rights to transfer back to you. But my point to you is to understand any contractual obligations that you may have. One of them is with the university, one of them is through funding agencies. Depending who funded your work, there may be rights that are associated with that you may not be well aware of. In the cases of where money came from grants, outright grants, there's usually not strings attached to that. But when it's a scholarship or a fund or something like that, there may be some attachment of rights to that or ownership. And when we go and look at small companies, oftentimes we find that this person used to work at, I don't know, University of Wisconsin or something. They left as a professor, they started their own company, but then when you dig into it, all that early work was done at the university, so what rights does that university still have in that? It may not be, they may truthfully believe that they own it, but when you dig deep enough, they may not own all of it or any of it to that extent. So my bullet point is make sure you understand your rights. there's a slight difference between the US and Canada. In the US, you are required to file patent applications in the name of the inventors. In Canada, you can actually file it in the name of the applicant. The applicant can be the inventor, or the applicant can be someone who owns the rights. So it's really important to actually, to the best of your ability, understand who all the inventors are to avoid issues later on when you may want to commercialize, or you may want to actually license it to other companies, because that's something companies do look at very carefully. Because you need to understand what you're buying, right? You go buy a car, you'd like to actually take it for a test drive, you want to make sure that you actually have bought the tires with the car as well, right? You don't have to go out and get something else. So really understand your employment agreements, understand your university policies, and understand whether there's joint inventorship or joint ownership. Because when you go to larger companies, like the company I work for, we want to be able to have freedom to operate, but we also want exclusivity. And patents give you, as I said, not a positive right, but an exclusionary right. And, you know, it's a contract between you, the inventor, and the public as represented by, Commissioner Patton's left, but the Canadian Patent Office, to give you an exclusive right for a certain length of time. Right now it's 20 years. And the return on that contract is that you then give your knowledge to the world so they can read it, so they can then use it to improve or use it afterwards. So you get the exclusion, but you've got to give up that knowledge. And patents do get published 18 months after your first filing. And, you know, that's something that companies look at very carefully, is that do they have exclusionary rights? Do they then have to, because if you then say, okay, I've got this great idea, but you then have to get licenses for 3 other patent portfolios that you don't have, then the value that you bring to the company is then diminished. And so what you thought was a $20 million may only be a $1 million. Now, $1 million's not bad, but it could be even less. So make sure you understand that you own the invention and that your rights are there. The other thing is we saw a little bit about how people in Canada are not filing in Canada. And I didn't get an opportunity to ask that question, but a lot of times people file in the US first because obviously that's a larger market. You then have 1 year to file in Canada. So you have to look at what your invention, what you think your invention is, and you have to look at your markets. And you have to look at not only your market, but also your potential, if it's a widget or something, where you're potentially going to manufacture it or where you think that manufacturing may occur. And you have to apply for patents in those countries too. Because patents are geographical, they're territorial. A Canadian patent does nothing for you in the US and vice versa. So if you only file the Canadian patent and the largest perceived market is in the US and it's going to be manufactured in China, that Canadian patent does nothing for you other than exclude that person from importing it into and selling it into Canada. So you have to look at the larger business picture as well. And that leads me into my final point, I think. I could go on forever, but I'll get the hook soon. Patents are expensive. To file a patent in Canada, just the cost of the filing fees, the governmental fees, is not that expensive. But you have to write the application, you have to understand the art, you have to do a patentability search. Generally speaking, these are done by people who are experts in the field, and those tend to be lawyers who work at large or small law firms who tend to charge between $250, $350, $400 an hour. So the more work you can do on your own to then bring that package to someone to do it, the less it will cost you, but it's not cheap. To file a patent in Canada, this is not terribly expensive initially, but there are fees that go on throughout the life of that patent. There are maintenance fees that you have to pay every year, starting on the 2nd anniversary. Patent lasts 20 years, so that's from year 2 to year 20, you've got to pay maintenance fees. They're escalating maintenance fees. They go up as the patent gets older. There's requests for examination fees. There's all sorts of other fees. There's issuance fees, but there's also prosecution. And you need an attorney to do that for you. You can do it on your own as an individual contributing inventor, but the chance of you getting the scope that you're going to need later on when you actually get to commercialization is minimal unless you let a professional do it. So you have to add those attorney fees to it. So the best thing to do as an entrepreneur is to obviously file a patent before you start talking to anybody, because in many countries there's an absolute novelty. In Canada, you do have a 1-year grace period where you can file in Canada or even in the US within the 1 year. But if you can find partners that will then pick up the costs of that patenting, that will certainly reduce the burden on yourself. But it is an expensive proposition. And it takes, as we heard, about 5 years in Canada to go from request for examination to potentially grant. Really depends on the technology field. In some cases, for example, the area that I work in, it could take 10 years. You could file a patent, you could finally get a grant maybe on year 15, 16, maybe 17, patent lasts 20 years. You've only got 3 years of exclusivity left. And in some cases, if you file very early, the development time, and as I said, the area where I work in, there are regulatory considerations, that patent could expire before you even get a product out. So you have to really understand the technology area that you're in. And that has to fit into your whole strategy, to IP, to venture capital, and I'll leave it at that.
Great. Thank you, Rizzi. David?
Thank you. So Rizzi, you have to give me the information about those attorneys that charge $250 to prepare this, because
yeah, they don't exist.
yeah, I'd like to hear more about this. So I'm really excited to be here. It's really difficult to understate the role of students in developing technology or innovations in the technology field. I mean, Jeremy made a few references to open text and others, but I mean, the technology sector just would not be the same if it wasn't for students on university campuses around the world, really, coming up with interesting software, hardware, et cetera. I mean, Google, Microsoft, RIM, OpenText, the list goes on and on. It's just, so it's really difficult to understate the tremendous contribution of students. And as a lot of these examples show, it's not always the typical supervisor, researcher type environment. It's quite often just people in a computer lab or in on their spare time on campus, sometimes using university resources, coming up with those inventions. So it's, I just wanted to mention that at the beginning, that as far as my sector, and I think Bill's sector is concerned, it's just central, really, the contribution of students. So, but when we look at the role of students, I think we have to think about it a bit more broadly. I mean, really, we're talking about, at least the way Microsoft views this, we're looking at it more in the context of generally how can universities and industry collaborate to advance the state of knowledge and advance technology, specifically for us in the computer science area. And so traditionally the role of universities has been, I'm oversimplifying, of course, but it's meant to do research in more pure sciences, basic fundamental areas, and then for industry to take that basic research and commercialize it and put it into products. Nowadays, I think it was Sylvain Laporte at the beginning that alluded to that with one of his slides. He was basically making the point that those traditional roles are now becoming increasingly blurred. And basically these different players in the environment are now really playing all of these functions, and that really adds to the complexity. And I think Microsoft is a good example of that. We have a division that's called Microsoft Research, MSR, which is, we spend about over $9 billion a year in R&D globally. We're one of the biggest R&D spenders in the world. So that division of Microsoft employs about 850 PhDs, just that division. And they basically do research in a variety of fields, primarily in computer science, but also in other areas of general science. I'm just mentioning this as an illustration of what I was saying earlier about even industry now starting to do fundamental research. We do that. And I think in the Waterloo region, There's actually another good example of that with RIM being really involved in the creation of the Perimeter Institute. So and that I think really underlines the interest of industry in just fundamental research. And so those traditional roles now are becoming really, really blurred and mixed up. So I thought I'd mention that. And another aspect of this complexity is the fact that a lot of companies now, and Microsoft is again a good example of that, were traditionally focused on doing research and development, getting IP for it, and then protecting it and enforcing it. And a lot of players such as Microsoft now have really switched their focus and switched their approach to this over the last 5 years, where we're now focusing on developing partnerships and collaboration with other players in the ecosystem, including universities, but as well as private or not-for-profit think tanks, and also even our competitors, where we're more and more focused on ensuring that the technology we develop, instead of keeping it to ourselves and protecting it, we actually push it out and we really try to license it to other players, so that they can build on it, and then we can actually access some of their technology and we can build on it. And as a result of that, basically the state of knowledge, the state of technology is going forward. So we've really tried to change that approach in the last few years, which is a new focus for a lot of us. And I think some of our competitors, such as Google, are increasingly in that focus as well. So the focus, the central driving engine that we see to the advancement of technology really is having this collaborative and licensed, approach to technology sharing. We feel that the IP framework is really central to this discussion, because in order to be able to transfer that technology from different players, including from universities to industry and vice versa, you need to have a legal framework. And in order to do that, you really need IP. You need to actually take that knowledge and crystallize it into patents. It's really important. And I'm mentioning that because there was a few references in some of the presentations this morning, and Jeremy alluded to that as well. A few of the speakers were saying, and I don't want to put words into their mouth, but a lot of them were saying, minimizing really the importance of actually getting the IP, and saying that getting patents is part of the puzzle, but it's really not the whole picture. And we agree with that. Of course, there's more to it than just getting a patent or IP in general. But we feel that it is a critical tool to ensure that knowledge is transferred from universities to the outside world. If you don't get the patents, then really, if you're an industry player, how do you really get access to? How do you license it? It's really difficult. So we really do believe that researchers, innovators, student innovators need to be encouraged to actually go out and crystallize that knowledge into patents and IP in general. We feel that it's really important, and it's a critical piece of ensuring that there's that sharing of technology, which, as I think it was Dr. Phipps was mentioning this morning, is actually part of the mandate of a lot of universities. Sharing that knowledge and ensuring that the state of science is going forward, and not just keeping it on a shelf inside the walls of universities. So we feel IP is central to this. So how much of that collaboration, between industry and universities is actually happening in Canada? Well, if you look at, there's been several studies done on this topic in the last few years. One of them, in fact, was done by Tom Jenkins, one of the founders of OpenText, and he was doing that as part of a federal task force on R&D support. And there's also been a lot of academic work, and I was reading yesterday on the plane a paper that was done a few months ago by Sam Trosso from University of Western Ontario on this. And the general theme, and I believe also, by the way, that the Standing Committee on Industry that Sylvain Laporte referred to this morning in its report that they issued a few days ago also referred to that. And I think the general consensus is that there's not enough of that collaboration in Canada. In fact, Canada, if you look at OECD surveys and studies on university-industry collaboration, really Canada ranks at the bottom of the OECD countries. And also, if you look at the number of patents that are being filed and granted by Canadian universities, We don't fare that well, especially if you compare it to the United States, which granted has different legal framework, but still, I mean, patents is one indicator of innovation, not the only one. I granted, and I know that it's an indicator that's been heavily criticized, but I do think it's an important one. And when you look at the number of patents that have been granted by two Canadian universities, it's pretty low. I mean, I think the last statistics that I saw, which was mentioned in Professor Trosso's paper, he talks about Statistics Canada reporting in 2008, so granted it's a few years old, only 346 patents being granted to Canadian universities that year, which was a drop of 20% from the previous year. That's concerning. That's in terms of industry trying to work with university and trying to get access to that technology, to those innovations, to build on it. That's a concern to us. And so we feel that more needs to be done to take that knowledge that's being developed and put it into a form that can be shared with industry. So how do we do this? How do we actually change and improve the level of collaboration between industry and universities? Well, as I said, I think the IP system is central. So there needs to be a culture where there is innovation, of course, in universities, and that already happens, but that innovation is converted into IP and shared with industry. You know, a lot of the solutions have been discussed today, but, you know, I think incentives for researchers and university students to actually do that is something that's helpful, and I know I think it was Dr. Phipps again that mentioned that this morning, that the federal budget yesterday did add new money for startups, for capital investments, and for generally ensuring that there's more innovation out there. And I think, you know, government funding helps, absolutely. I think as part of government funds, a lot of the funds that Mr. Mantel was talking about, I think it's important for government funders to ask university researchers when they provide funding to universities to do research. It's important for those funders to ask those researchers to provide reports on what are they doing to commercialize that IP and to get the IP and to commercialize it and to actually spread it out in the industry. I think it's important to that. If someone is forced to report on it, they're much more likely to actually to do a bit more effort to commercialize it. So that's another piece as well. There is a few mentions this morning about having courses in universities to non-law students in IP to help them. I actually think that's something that would be helpful in the engineering schools, for example, and perhaps the next speaker on the next panel, Professor Kozinski is going to talk about that perhaps, but I actually think it would be helpful. And I know that a lot of universities already do that. I realize that, but I think more would not hurt. Clear IP policies in the various universities, and I know York, I think has a fairly clear IP policy in terms of innovations that are done on campus, but not all universities have the same level of clarity, and I think it's important that all universities be on the level playing field. Setting up technology transfer offices, again, York I think has a solid one, but not everybody's on the same level playing field. Another one which was alluded as well, ensuring that student inventors, but in generally innovators and creators of IP on campus get a share of the royalties if they license out their technology. You know, certainly Microsoft is not suggesting that be legislated, but we're just saying it's a way to create an incentive for students to actually do that. So we think that it's a positive approach that a lot of universities should consider as part of their policies. Generally speaking, a last recommendation that I'll mention is taking steps to develop a relationship of trust between industry and universities. Like having more partnership, which sounds very motherhood and apple pie, I realize that, but it actually is important. You know, I think in universities there's quite often a level of mistrust of industry and thinking that industry is coming in with ulterior motives and all that. And also on the on the industry side, quite often we're not necessarily as well connected in the various research institutions and industries as we should be sometimes. So I think there needs to be more dialogue and more collaboration and that level of trust needs to be created. So some of the ways that you can do that, I guess, internships, making sure that some of the researchers get a chance to come and work in industry for little periods of time and vice versa. I think having those types of secondments and internships is one way. But generally collaborating on conferences, on research projects is important. So we think that all of that can help create that level of trust. So I'll stop there. I'm probably over my time, but thank you very much. Yep.
Great. Thank you. Appreciate the opportunity to speak to you today. I think I'm really going to talk a little bit more kind of like war story-ish, like in what IBM does in working with students, working with academia and the like. Certainly, IBM puts a lot of money into research. I'm not sure it's the same amount as Microsoft does. I'd have to look at the last annual report on how much we put into R&D. But certainly, IBM has had a lineage of innovation and research over the years. It's been the leader in issued U.S. patents for the last 19 years. For example, IBM Research is, much like Microsoft Research, its own separate group within IBM. It does a lot of research with employees, PhDs, and also does a lot of collaboration with academic institutions. Some of the things that you might see coming out from IBM Research, if someone watched Jeopardy last year and it was Watson, the supercomputer, and up against humans. And that was a product of IBM Research. And that's one of the areas of interface between students, the universities, and IBM. I certainly know of a lot of collaborations and studies and those types of things that do go on. Here in Canada, we have a group called the Centre for Advanced Studies, which is essentially a collaboration between IBM Canada and academic institutions where professors, students, grad students, et cetera, will work with IBM personnel. And this is to help, in a sense, really giving back to the community, because we're helping the professors and the students with their academic projects and bringing our expertise in various fields, whether it's software, IT, et cetera, to the fore and working with these universities and students and the like. So we do interface in that level. There, as I said, it's more of a collaboration between academia and the company, basically because we're trying to help them out with their quest for knowledge and such. On other levels, we have students that work with us as summer students. They're going to be treated as employees. And obviously, with that type of arrangement, there are going to be those types of contractual agreements, much like what Reza has mentioned earlier about who owns intellectual property and the like. Obviously, for commercial companies, what's important for us is to make sure that we have freedom of action for the intellectual property that's created and to make sure that we'll be able to use it, commercialize it, license, and so forth. So there are those opportunities for students to be working with us as summer students. We also have a program called Extreme Blue, which is to have graduate students work with us on particular projects, or maybe they might be coming up with projects on their own, along with being mentored by IBM personnel. And these students would be treated as employees as well. I think I echo David's comments that student work and collaboration with students is a very important part. We have, at least 3-4 different ways that we work with university students and academia. And so it is something that we look to as being an important part, not only that we give back to the community, the scientific community and the like, but also it has a benefit for us as a company because students come up with great ideas. They really do drive a lot of innovation. I remember my days as a graduate student. I don't think I drove a lot of innovation, but I was a graduate student. And even back then, I had realized, well, is my supervisor going to protect the innovations that are being created in the lab? And this was more of a biotech focus in the lab that I was at. And I thought, well, really should consider it. But I guess back in the early 90s, people were, or at least academic institutions, were not as focused on intellectual property and monetizing those assets. And so, even though I talked to my professor, he's, well, no, never got anything patented, so, but that's all water under the bridge. So there are those strengths that students bring to the table. Obviously, for us in business, commercial companies, and the desire to make sure that we have freedom of action, we are concerned about what are the potential contractual problems, as Reza has outlined. Obviously, as students, you're going to have to look at what your obligations are to the university. Some universities have much more liberal IP policies insofar as what students can own and what the supervisors own, what the universities own. You also have to be aware of what potential obligations you would have if you are a scholarship holder, whether you're getting NSERC funding. My experience from dealing with academic institutions in previous lives, current lives, et cetera, that there are going to be potential contractual obligations that would be of concern to a company because of scholarship funding that might come from a government or from other organizations. So as a student, you have to be aware of those things because it would potentially impact how attractive the intellectual property that you're bringing in to a company would be. And so there are all those things which aren't necessarily within your control, but those are the things that companies would be looking at. Insofar as being able to commercialize it, the real difficulty for students is that absent working with a commercial entity, the practical matter is that you're probably not going to be able to protect it via the patent route. It costs a lot of money to do so, and students generally don't have the background or expertise in patent law or IP law to be able to go out on their own to do this. I don't know how willing the tech transfer offices within universities are to help students, but I suppose it depends on the value of the innovation that they're bringing to the table. But certainly, the ability to prepare the patent application, file it, pay all the costs, et cetera, is probably outside the realm of 99.9% of the students that are out there who bring IP or innovation to the table. So unless you're with a company like Microsoft or Sanofi or IBM, that there's an agreement in place relating to who owns the IP and will protect that IP in the appropriate manner, it'll be difficult. And I don't think there are really the resources within the university system to be able to support that. And maybe that's something that the universities would have to take a look at. I'm pretty sure that the law schools will not be able to provide that type of a IP-type protection service because they just won't get the funding or the ability to do so because that's giving legal advice and all those other problems. Legal Aid Ontario is not going to fund a clinic for protecting IP. So the other thing that just comes to my mind is that in working with industry, students should be thinking about, your idea may be great, but at the end of the day, you have to be able to put that idea into a form that is crystallized. As Reza said, to get a patent, you're going to have to show that it actually works. And for us, when you're working with a company, coming with an idea, It's not just the idea. It's how you put that idea into practice, which will be what the intellectual property is, what the invention is at the end of the day. If you do find yourself in a situation where you are working with a company in trying to protect that IP, you will have obligations to, depending on the contract that you have with the entity, to assist in protecting the intellectual property, which means drafting the patent application in conjunction with an outside patent agent or a patent lawyer, signing documents. There are a lot of documents to sign, and there's potentially a fairly long tail to these types of obligations. Maybe there's the need to file in other countries, which means you have to sign more documents and this, that, and the other. And maybe you might even get involved in litigation. As an inventor, there's the possibility that you will be involved in litigation if your patent is being litigated. You might be deposed or take an examination for discovery. I liken it to frontal lobotomy without any anesthetic, but it's a pretty uncomfortable situation. I've been examined for discovery once, or cross-examined on an affidavit. Don't like it, and I'm a lawyer, so. So anyway, those are basically the war story. My kind of thoughts on this interaction between industry and students, and really what you should be looking for as a student, and the obligations that you'd have in trying to commercialize your product or your invention.
Yeah, wonderful. Thank you, Bill. So I want to make sure that we stick on schedule too, so I'll just give us a few minutes of questions. Any questions in the audience?
Hi, I'm Diana Ficini from George Brown College in the Office of Research and Innovation. I'd just like to actually thank the panel for a very interesting perspective, and one we shouldn't forget from the academic side, that we want to invent and patent with the purpose of being able to use them and to commercialize and to create economic and social benefit. So it's very important to have this group at the table. And maybe a point of clarification, I've heard a lot of talk about the universities today and not so much about the colleges. I can only assume that we're grouping them all together in the grand academic institutions within the province. My question is around academic and industry collaborations, and obviously they're quite important, and the government recognizes them as being quite important, and academic institutions recognize them as being very important in terms of pushing innovation forward. And I'm wondering, what do you feel the institutions are doing well, or maybe not so well, in terms of their IP policy, the way they negotiate with industry, perhaps the way the students and faculty behave in terms of IP once the projects are engaged, if you have any comments?
Maybe I'll start off with my personal opinion, not as representative of IBM, but my personal opinion based on my experiences over the last 17 odd years as a lawyer. I think that academic institutions have taken great strides to and realize the worth of intellectual property that's being created. But I think they also have to be realistic as to what the value is of their intellectual property that they're trying to commercialize, and take that realistic view when it comes to dealing with industry, as opposed to thinking that what I've got here that came out of this lab is the next best thing to sliced bread. And as such, in any dealings with commercial entities, that well, it's going to command a commensurate price. So I think it depends on the organization you work with, but I think that's just my personal opinion. I think they have to have a little bit more realistic view of what the value of the IP is at the end of the day, in order to try to accomplish their goals of doing a tech transfer or commercializing that IP.
Yeah, I'd also add, first of all, I completely agree. I've been probably in my presentation referring to universities, but absolutely colleges were part of what I intended to refer to, because there's no question that they contribute a lot to the state of knowledge, and particularly in the computer science area. There's a lot of great college innovators. But in terms of what the institutions, how could they improve their practices? I think a lot of institutions are focusing very much on taking those students that have great ideas and helping them maybe incorporate and start a company and all that and get financing. They're very helpful in that regard, I think. But in terms of taking that knowledge and helping them shop it around in industry to see if there's existing industry players who might be able to incorporate that knowledge into their products or into their product development cycle 3 or 4, 5 years down the road. That is something that I think I know in the US there's quite a bit of activity going on in a lot of tech transfer offices in universities and colleges. I don't know if there's as much in Canada. And I think that's a potential way of taking those innovations and pushing them out to the marketplace. That uses a lot of the institutions that are there, IBM, Microsoft, Sanofi, et cetera. So I'd say that aspect is something that I think maybe would need a bit more development in Canada.
So I think you can hear some similar comments, but I'll try to be slightly different. I think in my dealings with universities over the years, it's become better. It's obviously better to deal from a position of knowledge than one of naivete. And tech transfer offices in universities have gotten better and better. People are understanding what it is to get IP, what it is to commercialize, things like that. But the one, I think, common thing is that, and I think it's common with everybody, they always feel that their invention that they bring to the table is the next multi-billion-dollar invention. And it may well be, but I think what sometimes people forget is that IP is just a small component of it. You have to commercialize, you have to develop, you have to scale, you have to market. And those take, particularly in the area that I work in, clinical trials are the biggest cost center about any product. IP is a very small component of it. So you have to take all those things into account when you start to negotiate the value of what you're bringing to the table. And I think sometimes people put things out of perspective mainly because of lack of knowledge. So gaining a better understanding of the technology, I think, is the one thing that tech transfer offices can do.
Sure. Okay, I'm going to just say I love that you asked the question because for a bunch of reasons. I'm a product of the college system, and I think oftentimes colleges forget how fundamentally important they are to the innovation ecosystem and how in many, many cases, they better understand and are better attuned to industry relevance than universities are. Colleges often think of themselves as, the redheaded stepchild in the academic ecosystem. My business school was full of Queen's BCom grads who couldn't get jobs and were then inside colleges trying to get industry relevant training so that they could go get jobs. There's an unbelievable, untapped still opportunity for colleges and the colleges that have taken the initiative to create tech transfer offices to get their students engaged and get them really thinking about industry-facing opportunities that may exist for them. And I think your institution is one in particular that does a very good job of that in the GTA already. But I would encourage you and your colleagues to be really loud and proud about what you have to offer. Niagara College down just around St. Catharines is another great example of a college who really, really understands its relevance with industry and actively engages. They don't sit back and wait. They get proactive about engaging the horticultural industry that exists down in the Niagara region, and they find commercialization opportunities where industry guys are smart. These guys are in the business of making money. So they know where those beehives of activity are, and they're very, very quick to get engaged and offer the wherewithal that they have as industry players to get students engaged in solving real-world problems that create applications of IP.
Okay, well, we'll end there. Did you want to respond to that? Disagree. Okay. So I wanted to thank you for your wonderful question, and thank you to our panelists for our last session. A big round of applause.